Hi everyone. My name is Pranav Barnott from Win Legal. Very good to see you of what is our second online lunchtime webinar where we invite our clients for a free webinar just to kind of educate and give as much value as we possibly can on areas of law. And for today's topic, we are talking about the Renters' Rights Act, which essentially came into effect on the 1st of May last week. Perhaps one of the most transformative changes to the private rental sector in a generation. And for those of you who remember back perhaps in the 80s, that was the last time there was such a large scale change to the private rental sector. So we have seen another one, and we're almost a week into it. And one of the big things we noticed over the past a few weeks is we had about 41 Section 21 notices that came onto our desk. And it gives you a sense of how frantic many landlords have been in evicting tenants ahead of that deadline that came in on the 1st of May. So, when we're speaking to landlords at the moment, some landlords are saying, oh gosh, we're going to leave the market because it's just going to be impossible to get our tenants out. And other landlords are saying, we don't really know what's changed. And we're having a real mix of landlords that we're dealing with. Some people think it's the worst thing in the world, and some people actually don't quite actually appreciate how significant the new changes are. And the reality is that both landlords are probably not wrong, but it's something in the middle whereby it's not impossible to get your tenants out, but at the same time, there is sufficient changes to justify landlords kind of paying attention. So the first thing I would just like to say is, what happens now? So as of last week, many of you would have been aware that the Act came in, Section 21s can no longer be served on tenants. But what is the next big deadline? And for those of you who are landlords, please put a note in your diary if you haven't already. The next big deadline is the end of the month, the 31st of May 2026. And by this date, every landlord and managing agent should have given the renters' rights information sheet to the tenants. Okay, very, very important if you haven't already done that. The reason that's so important is because um, tenants need to know what the new changes are that have come in. They need to know that fixed term contracts have been abolished. They need to know there's no such thing as a Section 21 notice. They also need to understand that they can't have discriminatory policies within the tenancy agreements. For example, you can't ban pets. So if you haven't already, oh, there's a bit of, if you haven't already given those out to your tenants, please make sure you do. And it's not sufficient to just give your tenant a link. You've got to print off the prescribed form off the government website and make sure it's given in a form that can be read by the tenant. The other thing to also bear in mind is that managing agents are also required to serve this on the tenant. So it's not just the landlords, but it's the managing agents as well. If you don't do it, penalties can be up to £7,000. So it is very important that that isn't forgotten. So that's by the 31st of May. By the 31st of July this year, if you have served a Section 21 and haven't started court proceedings, that is the date by which court proceedings in reliance on the Section 21 notices have to have happened. So it's very important that you don't miss that deadline, which is incredibly important, the 31st of July 2026. If you haven't instructed lawyers to kind of get possession proceedings ready, that's by that point they have to be ready. And then later on in the year, towards the back end of 2026, as a landlord, just bear in mind that there is likely to be a private landlord ombudsman service, as well as a landlord database that you will have to sign up to. There's not too much information on that at the moment, but please just bear in mind that that's coming up on the horizon. So that's the first thing about what landlords need to know in terms of diary entries. So 31st of May, 31st of July, and then be ready for the end of the year in terms of subscribing to the various databases. The next thing is just bearing in mind some of the new changes, and I just want to kind of recap these to you. The Section 21 notice has been abolished, so you can't now rely on that. You've got to now rely on Section 8 notices if you want to evict a tenant. To put simply, if you want to evict a tenant, you now need to have good reason to do so. You can no longer do so on a no fault basis. Some of the common reasons that landlords might think about evicting might be if they want to move into their own property. Okay. And that is a reason for potentially eviction, but you have to give 4 months' notice to the tenant before you can take occupation, and you can't rely on it in the first year of the tenancy. Okay, so let me just make sure that I've said that so it's understood. If you need to move into your property, you can't give a notice within the first 1 year of that tenancy starting, and you have to give 4 months' notice to do so. The same applies if you're a landlord and you want to sell your property. You've got to give 4 months' notice, and it ought not to be done in the first 12 months of the tenancy starting. If you want to evict because your tenant hasn't paid rent, which has been the most common reason for evictions, you have to be in the tenant has to be in 3 months or 13 weeks of rent arrears, and you have to give 4 weeks notice. If up to last week it was 2 weeks, now it's 4 weeks notice. So something just to bear in mind and to be aware of. But to help landlords, if there is any antisocial behavior going on at the property or any concern that the property is being left in disrepair, or any sort of issue relating to how the tenants are conducting their use of the property, you can actually start eviction proceedings straight away. So on one hand, the government have made it easier if the tenants are not acting in the right manner to evict, but made it harder if you need to move in or if there's rent arrears. So just bear those kind of key provisions in mind. They are pretty important. There are lots of other reasons in which you can seek possession of your property, but I'm not going to go into all of them today because those are the most common ones. But interestingly, deterioration of furniture is a new provision that's come in. If you find that the tenants are deteriorating furniture, you can give 2 weeks' notice. So just bear that in mind. The next thing is rent increases, which has become a very popular topic that many of our clients are asking us about. From now, you can increase rent once a year. It's got to be by way of serving something called a Section 13 notice, which is a formal notice. The rent increase has to be the market rent, so it can't be anything you want. And if the tenant doesn't agree with it, they can go to tribunal. So we are going to expect more litigation around rent increases, but for landlords, you might want to just take care in making sure that any rent increases are happening once a year and in accordance with the market rate, and provide market evidence to, as best as you possibly can. Be realistic, provide comparables, and that should give you some defense if this ever went to tribunal. The next big change, obviously, is that fixed term contracts have come to an end. So up until last week, you could give, 1 year contracts or 2 year contracts. That's now changed. Every contract is now a periodic, so there's no end date, but tenants can give 2 months' notice if they wish to vacate. So if you are a landlord and you're simply relying on your previous tenancy agreements, which is very normal, bear in mind that it doesn't matter if there's a fixed term in there. As of last week, those tenancy agreements now become periodic. By periodic, they simply just roll on month after month after month. There is no end point to them. One thing that we are advising a lot of our clients to do is serve a new tenancy agreement called an assured periodic tenancy. And that will make sure it's compliant with the Renters' Rights Act. And we can give you a copy of that, a template, should that be helpful after this. And finally, I just want to say, if there is a market, if a property is set out with a rent on it, the government is discouraging and banning rental wars. So the maximum amount a landlord can charge for rent is going to be the amount that's been marketed for that rent. So you can't start playing one tenant after another, hoping you can get an increase in respect of the rent that you're charging. So that's quite a significant change, and one that's come in as of last week. Can I suggest that landlords are being very careful in terms of record keeping? It is becoming quite important that you're not only doing being a good landlord, but you can evidence being a good landlord. So as much as you can keep to electronic communication, having all your documents stored electronically in one place would be, I think, something that I would advise on. And unless you are a career landlord and have got a lot of time to invest in managing your property, it might be worth thinking about having someone helping you with the management or the compliance side because the rules are getting quite complex and the penalties are quite severe. So, and obviously there's still changes that are coming into place. And so just making sure that you've got someone kind of keeping an eye on that for you if you're very busy kind of working on your day job, I think I would recommend that quite significantly. And just finally, in terms of something I touched on earlier, you can't ban pets anymore. So if you have a property, you've got to have a good reason to ban pets. There has to be a reasonable excuse, and you can't have blanket prohibition. So no, you can't say no social security tenants or no children. So if your tenancy agreement says that, right now, that's in place. It's very important that that's changed because you could find yourself inadvertently falling foul of the rules. So please do check your tenancy agreements and make sure that those are compliant. And finally, as a landlord, you'd probably want to make sure that your referencing is very good. I know landlords are now going to be far more particular as to which tenants they're going to take on and make sure that credit checks are done and good reference checks are done. So that might be something you think about going forward if you're thinking about reletting your property in the long run.